The laws of driving under the influence vary between countries. One difference is the acceptable limit of blood alcohol content before a person is charged with a crime. Asia, Central Asia, Kyrgyzstan, 0.05%, Mongolia, 0.02%, Turkmenistan, 0.033%, East Asia, China, 0.02%. 0.78%. Beginning May 1, 2011, Chinese law now mandates a penal detention up to 6 months for any person convicted of drunken driving. Hong Kong, 0.05% or BRAC 0.22 mg per litre or urine 0.067%. Driving under the influence of alcohol beyond legal limit is punishable with a monetary fine and up to 3 years imprisonment, with 10 driving offence points and mandatory driving improvement course. Japan, BRAC 0.15 mg per litre. Additionally, regardless of alcohol readings, police may also determine the driver to be driving drunk, which is punished more severely than exceeding the designated alcohol limits. Republic of Korea, 0.05%, Taiwan, 0.05%, over 0.05% but under 0.11%, 15,000 new Taiwan dollars to 90,000 new Taiwan dollars fine, and license suspension for 1 year, 0.11% and above, license suspension for 1 year, and charge of offences against public safety with possible prison sentence up to 2 years as the maximum penalty. If the driver is convicted of causing accidents, the penalty shall be increased by half. If the driver causes serious injuries or death, the license will be suspended for life or even face the death penalty. South Asia, India, 0.03%. This is according to Section 185 of Motor Vehicles Act 1988. On a first offence, the punishment is imprisonment of 6 months and/or fine of 2,000 Indian rupees. If the second offence is committed within 3 years, the punishment is 2 years and/or fine of 3,000 Indian rupees. The clause of 30 mg per deciliter was added by an amendment in 1994. It came into effect beginning November 14, 1994. Nepal, 0%. Breathalyzer testing is regularly used in major cities like Kathmandu, Pokhara, Biratnagar and highways. For more verification, driver will be taken to nearest hospitals for blood and urine test. License will be seized instantly. Driver will get the license back after attending anti-alcoholic classes run by Nepal Traffic Police and fine will be charged Rs 1,000. Pakistan, falls under drink and drugs, S. No 14. No set limit. 8 penalty points. Sri Lanka, 0.06%. Breathalyzer testing is not used routinely. If suspected by police, the driver is produced before the closest government medical officer who examines and determines whether the driver is under influence. If the driver refuses examination by the medical officer, he is considered to have been under influence by default. Southeast Asia, Brunei, alcohol is banned. Cambodia, 0.05%, Laos, 0.80 mg per 100 milliliters of blood, Indonesia, no limit, Malaysia, 0.05%, Philippines, 0.05%, Singapore, 0.08% or BRAC, 35 micrograms of alcohol per 100 milliliters of breath, strictly enforced. Thailand, 0.05%, Vietnam, 0.50 mg per 100 milliliters of blood motorbikes and 0.80 mg per 100 milliliters of blood for cars, Western Asia, Armenia, 0, Azerbaijan, 0, Georgia, 0.03%, Iran, 0. It is illegal for Muslims to make, sell or possess alcohol for use as a drug. Some forms of ethanol are allowed for scientific, medical and industrial use. In addition, non-Muslim minorities are permitted to make and possess small amounts of alcohol for their own use. Israel, 24 mg per 100 milliliters of breath. New drivers, drivers under 24 years of age and commercial drivers 5 mg per 100 milliliters of breath. Jordan, 0. Breathalyzer testing is not routinely used. If suspected by police, the driver is produced before the closest government medical officer who examines and determines whether the driver is under influence. Kuwait, no limit, alcohol is banned. Saudi Arabia, no limit, alcohol is banned. United Arab Emirates, 0. Africa, Angola, 0.06%, Algeria, 0.01%, Benin, 0.05%, Cape Verde, 0.08%, Central African Republic, 0.08%, Comoros, no limit, Congo, no limit, Egypt, 0.05%, Equatorial Guinea, 0, Eritrea, 0, Ethiopia, no limit, The Gambia, 0, Ghana, 0.08%, Guinea, 0, Guinea-Bissau, 0.05%, Kenya, 0.08%, Malawi, 0, Mauritius, 0.05%, Namibia, 0.05%, Niger, 0.08%, Nigeria, 0, Seychelles, 0.08%, South Africa, 0.05% and 0.02% for professional drivers. National Road Traffic Act, 1996, Togo, 0.042%, Uganda, 0.08%, Tanzania, 0.05%, Zambia, 0.08%, North America, Canada. Canada, 0.05 to 0.08%. The Criminal Law Amendment Act, 1968-69 made it a per se offense to drive with a blood alcohol content in excess of 80 mg/100 ml of blood. Refusal of a police officer's demand to provide a breath sample was made an offense at the same time, and both began as summary conviction offenses, with a mandatory minimum $50 fine. Driving under the influence of alcohol is a generic term for a series of offenses under the Criminal Code of Canada. The main offences are operating a motor vehicle while the ability to do so is impaired by alcohol or a drug, contrary to Section 253(a) of the Canadian Criminal Code, and operating a motor vehicle while having a blood alcohol concentration of greater than 80 mg of alcohol in 100 ml of blood, contrary to Section 253(b) of the Criminal Code. See Section 253 of the Criminal Code. Both offences can be committed by a person who is actually operating or driving a motor vehicle, vessel, aircraft, or railway equipment, or by a person who has care or control of such a vehicle. Care or control includes actual care or control and presumed care or control. Section 260(1)(a), where the person occupies the driver's seat. The latter is often the case where police find an individual sleeping behind the wheel. The offences are usually investigated by the police coming across a driver with either an erratic driving pattern or who has been pulled over. The police may immediately have grounds to arrest for impaired driving and make an approved instrument demand under Section 254(3). Those grounds are based on various indicia of impairment. If the police merely have a suspicion of alcohol in the individual's body, they may make a demand under Section 254(2), requiring the driver to give a sample of his or her breath into an approved screening device, which will determine the driver's blood alcohol concentration on a preliminary, non-evidentiary basis. Based on the screening device results, if the police believe on reasonable and probable grounds that the driver is committing an offense under Section 253 of the Criminal Code, the police can demand that the driver go to the police station to give samples of his or her breath for an approved instrument test, which would be used to prosecute the driver for over 80 mg of alcohol in 100 ml of blood. The minimum punishments for impaired driving and driving over 0.08% are, for the first offense, $1,000 fine, 1 year driving prohibition. For the second offense, 30 days jail, 2 year driving prohibition. For the third or subsequent offense, 120 days jail, 3 year driving prohibition. In addition to the federal criminal laws, all provincial governments have enacted their own measures against impaired driving. Such laws complement the federal laws. Some provinces will suspend a driver's license upon him or her being charged with impaired driving, rather than being convicted. Some provinces will automatically impose a license suspension that runs longer than the driving prohibition handed down by the court. Provincial and federal driving prohibitions run concurrently if imposed for the same offence, at the same time. In Ontario, a person convicted of a DUI must also complete an 8-month training course and install an ignition interlock device for a period of 1 year after the license suspension. Jail time can be imposed for any first-time criminal code drinking and driving offence. Jail is appropriate where there is an accident and/or the readings are high. Readings above 160 mg/100 ml are an aggravating circumstance. Jail is the minimum punishment for second and third offences. Foreigners with recent drunk driving criminal convictions are generally refused entry at the border. Drunk driving charges that can make an individual criminally inadmissible to Canada include, but are not limited to, driving under the influence, driving while intoxicated, driving while impaired, operating while intoxicated, operating a motor vehicle while intoxicated, and driving while ability impaired. Canada's Immigration Act Section 36 considers any foreign drinking and driving outstanding charge or conviction as an indictable offence unless a prosecutor has chosen to proceed by summary conviction. Criminal inadmissibility can be overcome permanently by criminal rehabilitation or temporarily by obtaining a temporary resident permit. On January 27, 2001, Andrei Nyatsev, a Russian diplomat in Canada, killed a Canadian woman while drinking and driving. He was imprisoned in Russia. This incident triggered a crackdown on drunk driving by diplomats in Canada. On December 15, 2005, Charlie Hart of Watford, Ontario, a man with a 35-year history of impaired driving which included 39 convictions, was on the occasion of his latest such conviction sentenced to 6 years in prison, the most severe penalty ever handed down in Canada when the offence did not involve a fatality, and the maximum sentence permitted under the law. Mexico, 0.08%, foreigners with recent drunk driving criminal convictions are generally refused entry at the border. Mexico's Immigration Act Section 36 considers any foreign drinking and driving outstanding charge or conviction as an indictable offense. United States, 0.08% BAC by volume. Some states now have 2 statutory offenses. The first is the traditional offense, variously called driving under the influence of alcohol, driving while intoxicated impaired or operating while intoxicated impaired. The second and more recent is the so-called illegal per se offense of driving with a blood alcohol concentration by volume of 0.08% or higher. In most states, the timing of the chemical test is important because the law mandates a result within a given time period after the driving stopped, usually 2 hours. The first offense requires proof of intoxication, although evidence of BAC is admissible as rebuttably presumptive evidence of that intoxication. The second requires only proof of BAC at the time of being in physical control of a motor vehicle. An accused may be convicted of both offenses, but may only be punished for one. The differences between state penalties still waivers. Wisconsin, for instance, is the only state that continues to treat first offense drunk driving arrest as forfeiture. It is also a criminal offense in all states to drive a vehicle while under the influence of drugs (DUID), or under the combined influence of alcohol and drugs. The drugs themselves need not be illegal, but can be prescription or even over-the-counter. In some states, the effects of some herbal remedies fall into this category. Several states also have enacted statutes to create a DUI offense by virtue of huffing noxious fumes, such as glue sniffing or inhaling similar volatile chemical fumes. 6. DUI impairment statutes require that violations be supported by evidence of impairment as a result of the alcohol or other drugs, or combined, or by any noxious vapors. Some states have recently passed laws making driving with the mere presence of certain drugs a criminal offense. These new statutes are sometimes referred to as DUI drugs per se statutes. Some states also include a lesser charge of driving with a BAC of 0.05%. Other states limit this offense to drivers under the age of 21. All states and D.C. also now have zero-tolerance laws. The license of anyone under 21 driving with any detectable alcohol in their bloodstream will be suspended. In 2009, Puerto Rico joined these states, setting a limit of 0.02 for drivers under 21, despite maintaining a legal drinking age of 18. The blood alcohol limit for commercial drivers is 0.04%. Commercial drivers are also subject to stricter punishments for exceeding the blood alcohol limit. According to the NHTSA, drivers are considered to be alcohol impaired when their blood alcohol concentration is 0.08 grams per deciliter or higher. Thus, any fatality occurring in a crash involving a driver with a BAC of 0.08 or higher is considered to be an alcohol-impaired driving fatality. The term a driver refers to the operator of any motor vehicle, including a motorcycle. Pilots of aircraft may not fly within 8 hours of consuming alcohol, while under the impairing influence of alcohol or any other drug, or while showing a blood alcohol concentration equal to or greater than 0.04 grams per deciliter of blood. The various versions of driving under the influence generally constitute a misdemeanor. However, the offense may be elevated to a felony if the incident caused serious injury, death, or extensive property damage, or if the defendant has a designated number of prior DUI convictions within a given time period. California, which is being followed by a growing number of states, now charges second-degree murder where the legal state of mind of malice exists, that is, where the defendant exhibited a reckless indifference to the lives of others. California. A California DUI arrest triggers two separate cases, one in court and another at the California Department of Motor Vehicles. The criminal case typically involves two different counts. The first, under California Vehicle Code Section 23152, is driving under the influence of alcohol, which is commonly known as the A count. The second offense, under California Vehicle Code Section 23152, is a related charge of driving with a blood alcohol content of 0.08% or greater, or the B count. The second charge is the one that triggers the California Department of Motor Vehicles DUI case, where the California DMV will attempt to suspend the motorist's driving privileges. Drivers convicted of DUI criminal court face substantial punishment that can include fines, jail time, probation, alcohol education school, and a driver's license suspension that separate from the one imposed after a lost DMV hearing. The amount of punishment depends on the facts of the case, including how many prior DUI convictions the driver has. California DUI convictions count as prior offenses for 10 years, meaning that drivers who were arrested for DUI within a decade of a prior drunk driving offense will be charged with a repeat offense. If more than 10 years has passed since a prior DUI arrest, a subsequent drunk driving offense will be charged as a first offense. The time period is measured from arrest date to arrest date. Anyone arrested for DUI in California must request a DMV hearing within 10 days or have their driver's license automatically suspended. The California DMV hearing that follows a DUI arrest is a civil matter, not a criminal case, so there is a much lower standard of proof than in criminal court. Whereas in criminal court guilt must be proven beyond a reasonable doubt, at the DMV the standard of proof is by a preponderance of the evidence, which is often described as 50% plus a feather. This means that the DMV hearing officer must only establish that it's more likely than not that the driver violated California DUI laws. The hearing officer at a California DMV hearing acts as both judge and prosecutor. The issues at hand will depend on whether the driver took a chemical test to determine the blood alcohol content, or BAC. If the driver took a breath or blood test to determine the BAC, the DMV hearing officer will seek to establish three facts: whether police had probable cause to arrest the driver, whether the arrest was lawful, and whether the driver had a BAC of 0.08% or greater in violation of California law. If the driver is accused of refusing a chemical test, the hearing officer will seek to establish whether the driver was properly advised of the consequences of refusing the test, and whether he or she continued to refuse after receiving that warning. Drivers who lose their DMV hearings following a California DUI arrest face substantial driver's license suspensions. The length of the driver's license suspension depends on how many prior DUI arrests the driver has and whether or not a chemical test was taken. For example, a first-time DUI arrest where the driver took a chemical test will result in a 4-month suspension, while a first-time arrest with a chemical test refusal will result in a 1-year driver's license suspension. Virginia. In Virginia, a person can be charged with a DUI for driving under the influence of alcohol, regardless of his or her BAC. Under the influence of drugs. With a blood alcohol concentrations greater than 0.08 per 210 liters of breath. Or under the combined influence of drugs and alcohol. If charged with a first or second offense DUI, it is punishable as a Class 1 misdemeanor. This means that the charged individual would be facing up to 12 months in jail and a fine not more than $2,500. A third offense is a felony in Virginia. Like California, the punishment for a DUI is aggravated for subsequent offenses that occur within a 10-year period. However, any offense committed after a conviction of a felony DUI will remain a felony offense regardless of the time period between offenses. If a person has never been convicted of felony DUI and more than 10 years passes between offenses, the person will only be charged with a first offense. The time period is measured from the date of the offense. In Virginia, a conviction prompts the DMV to suspend the license of the offender for the requisite period of time depending on the offense. There is no subsequent DMV hearing in Virginia. If the DUI offense involves the use of alcohol, Virginia law permits the fact finder to infer intoxication if the person's BAC is 0.08 or higher as measured on a chemical test. If the person's BAC is less than 0.05, Virginia law presumes that the person is not intoxicated. However, there is no presumption for a BAC greater than 0.05 but less than a 0.08. This means a person could be convicted of a DUI with a BAC as low as 0.06. In addition to these presumptions, Virginia law also presumes that a person is under the influence if he or she has certain levels of specific drugs in their system. DUI investigation. One of three things must happen to trigger a DUI investigation: there must be an observed violation of the law, a driving pattern so suggestive of driving under the influence of alcohol or other drugs so as to provide a reasonable suspicion that a crime has taken place, or a lawful roadblock or checkpoint. One reason drivers are stopped on suspicion of DUI is because of driving patterns such as weaving, driving too slowly, or rapid braking or acceleration. Some of the most common reasons police stop drivers, such as speeding, are unregistered trademark T recognized as DUI driving patterns by the National Highway Traffic Safety Administration. Administrative license suspension. Law enforcement officers conduct field sobriety tests, including the use of portable breath analyzers for the purposes of determining if probable cause exists for an arrest. Until an arrest has been made, a motorist is under no obligation to perform any test. Most states consider such a pre-arrest refusal inadmissible in court. Depending on previous offenses or refusals, licenses may be automatically suspended for a period of 90 days to 5 years, or permanently revoked for multiple DWI convictions. As of 2010, only 8 states did not have ALS laws: Kentucky, Michigan, Montana, New Jersey, Pennsylvania, Rhode Island, South Dakota and Tennessee. And Steradian-22 is an official documentation required to redeem a suspended driver's license and get a car registered at the local Department of Motor Vehicles. A Steradian-22 filing is a form issued by an insurance company which removes a suspension order placed by the DMV's office on an individual's driving privilege. The most common reason for an Steradian-22 filing is an arrest for driving under intoxication or driving while intoxicated. The filing provides a guarantee to the state that an insurance company has issued at least minimum liability coverage for the person making that filing and that the insurance company will notify the DMV should the insurance ever lapse for any reason. Drivers in the state of Florida who are not lawfully arrested with reasonable cause by a law enforcement officer do not have to submit to any on-the-spot chemical or physical alcohol testing. In Arizona, a refusal to submit to a chemical test often results in the police obtaining a search warrant and, if necessary, forcibly taking the suspect's blood. Caribbean, Bahamas, 0.08%, Cuba, 0.01%, Dominican Republic, 0, Jamaica, 0.035%, Trinidad and Tobago, 35 I 1/4 g/100 ml BRAC/80 mg per milliliter BAC, Central America, Belize, 0.08%, Costa Rica, 0.075%, El Salvador, 0.05%, Guatemala, 0.08%, Honduras, 0.07%, Nicaragua, 0.08%, Panama, 0.08%, South America, Argentina, 0.00%, Bolivia, 0.07%, Brazil, any BAC up to 0.06% results in a fine and 12-month suspension of the driver's license. Anything above 0.06% is considered a criminal offense. Chile, from March 15, 2012, 0.03%-0.08%. The driver is considered to be driving under the influence and carries a 3-month suspension and a fine of $82 $410. Over 0.08%. The driver is considered to be drunk and carries a prison term of 61 to 301 days, a fine of $164 $820 and a 2-year suspension for the first offense, a 5-year suspension for a second offense, and a life suspension for a third offense. Colombia is known to have the toughest penalties against those driving under the influence in all of Latin America and practice a zero policy on DUIs. If a driver is found to be driving between 20 and 39 milligrams of ethanol for every 100 millimeters of blood, the driver is to have their license suspended for a year, pay a fine of $914, and serve 20 hours of community service. In the most extreme cases, if a driver is found to be driving with grade 3 alcohol, the driver is to have their license confiscated for 10 years, pay a fine of $7,314, and serve 50 hours of community service. If the driver gets in an accident and causes injuries and/or deaths, the driver is to face between 2.5 and 18 years of prison sentence. Ecuador, 0.07%, Guyana, 0.01%, Paraguay, 0, Peru, drivers below a 0.05% BAC will be given a warning. At a 0.05% and over, the driver will be given a fine and a license suspension of no less than 6 months and no more than 2 years. If the driver is involved in an accident without causing death or severe injury to another individual, he or she may possibly face jail time. If the driver causes an accident with a BAC over 0.101%, involving death or severe injury to another party, he or she will receive a mandatory prison sentence of 3 to 5 years. The driver's license will also be permanently revoked. Suriname, 0.08%, Uruguay, 0.03% for amateur drivers and 0 for professional drivers, Venezuela, 0.05%. Europe. European Union, note, 0 usually means below detection limit. Austria, 0.05%, 0.01% for drivers who have held a license for less than 2 years and drivers of vehicles over 7.5 tons, Belgium, 0.05%. Fines and driving bans increase as the alcohol concentration in the blood increases. Bulgaria, 0.05%, Czech Republic, 0, Croatia, 0.05%, Cyprus, Denmark, 0.05%, imprisonment if over 0.20%, 0 if not driving safely. Fine, 1 month's pay after taxes. Estonia, 0.02%, Finland, 0.05%, 0.12%. The penalty is a fine or jail up to 6 months plus license suspension from 1 month to 5 years. For aggravated, also a prison sentence is possible, usually as a suspended sentence. Routine breath testing without a probable cause is permitted and often practiced. Penalties vary by level of intoxication. France, 0.05% or 0.02% for bus drivers, 0.08%, Germany, 0 for beginners as well as drivers making commercial transportation of passengers. 0.03% in conjunction with any other traffic offense or accident. 0.05% without evidence of alcoholic impact. Penalty for 0.11% is a 500 fine and the driver's license is withdrawn for at least 6 months, but usually about 1 year. For 0.16% or higher, re-granting of the license requires a successful medical psychological assessment. If someone is caught with more than 0.11% or higher within 10 years of the last DUI incident with more than 0.05% and he is found guilty of DUI, it carries a minimum of 1.000 fine and a license suspension of at least 1 year. He is to take and pass successful an MPU and is required to prove to the court that he has been sober for the last 12 months, before he can get his license back. Note that the fine is doubled for second offenders and so on, regardless of how much the driver was over the limit. Also, usually German courts will hand out an extra fine to drivers for DUI offences, regardless of the already set penalty. If over 0.11%, the German courts usually also require the DUI offender to do unpaid community service. Riding a bicycle in Germany, the limit is set to 0.16%, as long as the rider is not involved in an accident. If a cyclist is caught with more than 0.16%, he is facing the same penalties as if he would have been driving a car with more than 0.16% of alcohol. Gibraltar, 0.05%, Greece, 0.05%, reduced to 0.02% for unlicensed or new drivers who have held a license for less than 2 years, motorcycle and professional drivers. Above 0.11% is considered a flagrant misdemeanor punishable with up to 2 years of imprisonment and a hefty fine in the court plus the revoking of the driver's license for 6 months. Routine breath testing without a probable cause is permitted and practiced by the traffic police, especially on weekends and major holidays. Hungary, 0, Ireland, 0.05% generally or 0.02% for learner drivers, newly qualified drivers and professional drivers, and those who do not have their driving license on them when stopped by the Garda. Police do not need a reason to request a breath sample. Being convicted of drunk driving usually carries a 2-year ban as well as a 1,500 fine. Italy, from 0.05% to 0.08%, from 0.08% to 0.15%, over 0.15%, 0 for drivers with less than 3 years experience and professional drivers. License is always revoked in case of professional drivers, second offense committed within 2 years or in case of an accident. If the driver refuses examination, he is considered to have been under influence by default, applying the over 0.15% rules. Limit is 0 for newly qualified drivers. Routine breath testing without a probable cause is permitted and practiced by various law enforcement agencies. Latvia, 0.02% for drivers with less than 2 years of experience and 0.05% for those with more than 2 years of experience. Lithuania, 0.02% for drivers with less than 2 years of experience and 0.04% for those with more than 2 years of experience. Luxembourg, 0.02% for professional drivers and drivers with less than 2 years of experience and 0.05% for the rest. 0.08% earns you a citation. 0.12% means loss of license. Malta, 0.08%, Netherlands, 0.05%, 0.02% for drivers with less than 5 years experience. Poland, 0.02%, 0.05%. Limits and penalties for riding the bicycles were same as for motorized vehicles to December 2013. Almost half of people imprisoned for drunk driving were riding bicycles. Portugal, 0.05%, Romania, 0.0%. Above 0.8 grams per liter, imprisonment of 1 to 5 years. Under 0.8 grams per liter, civil fine with possible suspended license. Slovakia, 0. Slovenia, 0 for drivers with 3 years or less experience and professional drivers, 0.24 mg per liter for all others. Spain, 0.05% and 0.03% for drivers with less than 2 years experience and drivers of freight vehicles over 3.5 tons, and of passenger vehicles with more than 9 seats. Surpassing the limit is a serious offence, fined with a 500. Driving with an alcohol rate over 0.12% is a crime. Sweden, 0.02%, 0.10%. United Kingdom, 80 mg of alcohol per 100 ml of blood, 35 ai 1/4 g per 100 ml of breath or 107 mg per 100 ml of urine. The Scottish Government is planning to reduce the limit to 50 mg of alcohol per 100 ml of blood from December 2014. Further rules in the United Kingdom. In the UK, driving or attempting to drive whilst above the legal limit or unfit through drink carries a maximum penalty of 6 months imprisonment, a fine of up to £5,000 and a minimum 12 months disqualification. For a second offence committed within 10 years of conviction, the minimum ban is 3 years. Being in charge of a vehicle whilst over the legal limit or unfit through drink could result in 3 months imprisonment plus a fine of up to £2,500 and a driving ban. Causing death by careless driving when under the influence of alcohol or other drugs carries a maximum penalty of 14 years in prison, a minimum 2-year driving ban and a requirement to pass an extended driving test before the offender is able to drive legally again. It is an offence to refuse to provide a specimen of breath, blood or urine for analysis. The penalties for refusing are the same as those for actually drunk driving. The offence of driving whilst under the influence of alcohol is one to which there is no defence, as such. However, it may be possible to argue that special reasons exist which are such that you should not be disqualified from driving despite having committed the offence. Special reasons are notoriously difficult to establish and the burden of proof is always upon the accused to establish them. Such reasons may include shortness of distance driven, unintentional commission of the offence, emergencies, magistrates' sentencing guidelines. In England and Wales, when DWI offenders appear before a magistrates' court, the magistrates have guidelines they refer to before they decide on a suitable sentence to give the offender. These guidelines are issued by the Sentencing Guidelines Council and cover offences for which sentence is frequently imposed in a magistrates' unregistered trademark court when dealing with adult offenders. Offences can either be tried summarily, which means they can only be heard in the magistrates' court, or they can be either way offences, which means magistrates may find their sentencing powers are insufficient and indict the case to Crown Court. The majority of drunk driving offences are summary-only offences which can only be tried in a magistrates' court. Only the most serious offences such as a collision and/or death injury involved are indicted to Crown Court. The maximum sentence magistrates can usually impose is a £5,000 fine and/or a 6-month prison sentence. As with England and Wales, road traffic law in Scotland is in the main framed within the Road Traffic Act 1988 as amended. Prosecution and disposal of drink drive offences is broadly similar to England and Wales, with less serious cases prosecuted on complaint through the sheriff summary courts. Cases involving aggravations, life-changing or fatal injuries are prosecuted on indictment via the Sheriff's Solemn or High Court. As with most UK-wide legislation, the penalties and sentencing guidelines for drunk driving in Scotland mirror those in effect in England and Wales. Other European countries: Albania, 0.01%, Belarus, 0.03%, Bosnia and Herzegovina, 0.031%, Iceland, 0.05%, Liechtenstein, 0.08%, Macedonia, 0 for professional drivers, public service drivers, commercial transport and drivers beginners, 0.05% for all others, Moldova, 0.03%, Norway, 0.02%. Punishment depends on the alcohol level: 0.02%, 0.05%, 0.10%, 0.15%. The guidelines state that the fine for an alcohol level of more than 0.05% should be around 1.5 months' base salary and usually not lower than 10 Norwegian kroner. For 0.02 to 0.05% the fine is lower. Prison sentences are usually around 3 weeks to 3 months with a maximum of 1 year. The suspension period varies from less than a year to 2 years. Russian Federation, 0.0356% since September 1, 2013, previously 0 since 2010. Switzerland, 0.05%. Serbia, 0.03% for all, 0 for motorcycle drivers, professional drivers, public service drivers, commercial transport and beginning drivers. Turkey, 0.05%, 0 for commercial transport and public service drivers. Ukraine, 0.02%, Oceania, Australia. Road laws are state or territory-based, but all states and territories have set similar rules. Australian law allow police officers to stop any driver and perform a random breath test without reason. Roadblocks can be set up, for example leading out of town centres on Friday and Saturday nights, or during football or other events, where every single driver will be breath tested. This differs from UK and US laws, where police generally need a reason to suspect that the driver is intoxicated, before requesting a breath and or sobriety test. It is an offence to refuse to provide a sample of breath when requested, with severe penalties including prison. Australian Capital Territory, 0 for drivers holding a learner, provisional, restricted or probationary licence, and for drivers operating heavy vehicles over 15 tgvm or driving a public vehicle for hire or reward, and all motorcyclists, 0.05% for all other drivers. New South Wales, 0 for learner and provisional licences, and all motorcyclists, 0.02% for drivers of vehicles of gross vehicle mass greater than 13.9 tonnes, vehicles carrying dangerous goods or public vehicles such as a taxi or bus, 0.05% for all other drivers, 0 limit for methamphetamine, cannabis and MDMA. Northern Territory, 0 for provisional licence holders and all motorcyclists, 0.05% for all other drivers. Queensland, a 0 limit applies to the drivers of trucks, buses, articulated vehicles, vehicles carrying dangerous goods, pilot vehicles, taxis, all learner drivers and provisional drivers and all motorcyclists, 0.05% for other drivers. 0 limit for methamphetamine, cannabis and MDMA. South Australia, 0 limit for learner, provisional, probationary, heavy vehicle, taxis, licensed chauffeured vehicles, dangerous goods, and bus licenses, 0.05% for all other drivers. 0 limit for methamphetamine, cannabis and MDMA. Tasmania, 0 limit for learner, provisional, truck, bus, and taxi licenses, 0.05% for all other drivers. 0 limit for methamphetamine, cannabis and MDMA. Victoria, 0 limit applies for unlicensed drivers, holders of learner permits and probationary licenses, professional drivers, and certain relicensed drunk drivers. Below 0.05% for most other drivers. 0 limit for methamphetamine, cannabis and MDMA. There are also other restrictions for drivers in Victoria. Limits apply within 3 hours of driving, that is, police can require a person to submit to an alcohol or drugs test within 3 hours of driving, and it is an offence to fail that test, unless the drug or alcohol use occurred after driving. Licenses cancelled for certain serious drunk driving offences may only be reissued after obtaining a court order. This is the case for repeat offenders, and first offenders above 0.15%. In such cases, the relicensed driver is subject to a 0 limit for 3 years following relicensing, or for as long as the person is required to use an alcohol interlock. Alcohol interlocks must be imposed whenever a repeat drunk driver is relicensed. A court also has discretion to impose an alcohol interlock when relicensing a first offender in certain serious cases, generally when the offense involves a BAC of 0.15% or higher. The law requires interlocks to be used for certain minimum periods, but the requirement to use an interlock does not automatically end at the completion of the minimum period. Once that period has expired, an individual may apply to a court to have the interlock condition removed from their driver's license. The state police must be given notice of the application and may make submissions to the court on whether the interlock condition should be removed. The court will also take into account data recorded by the interlock itself. Driving without an interlock when one is required carries severe penalties, including imprisonment. If a doctor sees any patient who is aged 15 years or over as a result of a motor vehicle accident, the patient must allow the doctor to take a blood sample for testing for alcohol and drug content in a way that preserves the chain of evidence. If this process is skipped, the doctor may not be able to discover the alcohol blood level. The results can be used as evidence in subsequent court proceedings. The law allows a police officer to require any driver to perform a random saliva test for methamphetamine, cannabis or MDMA, all of which are subject to a zero limit. Western Australia, 0.02% for learner, provisional license holders or persons convicted of driving under the influence and failing to comply with a request for breath, blood or urine, 0.05% for all other drivers. Readings over 0.08% but under 0.15% BAC, and 0.15% BAC and above comprise separate offences, the latter attracting heavier penalties. Persistent offenders may be barred from driving for terms up to and including life, and may also be imprisoned. The law allows a police officer to require any driver to perform a random saliva test for methamphetamine, cannabis or MDMA, all of which are subject to a zero limit. New Zealand operates a program called compulsory breath testing, which allows police to stop motorists at any time. CBT is usually carried out at roadside checkpoints, but mobile patrol cars can also randomly stop motorists to administer a test. The police also carry out roadside drug tests upon motorists they suspect have used drugs. The system in New Zealand is age-based. Since midnight on August 7, 2011, the limits are, 0 limit for persons under 20 years, 0.08% BAC or 400 I1/4 gram per litre breath for persons 20 years and over. The penalties for exceeding the limits are, persons under 20 years, up to 0.03% BAC/150 I1/4 gram per litre breath. Instant $200 New Zealand dollars fine and 50 demerit points. Persons under 20 years, 0.03% to 0.08% BAC/150 I1/4 gram per litre to 400 I1/4 gram per litre breath, up to 3 months imprisonment and or up to 2,250 New Zealand dollars fine. Loss of license for 3 months or more. All persons over 0.08% BAC/400 I1/4 gram per litre breath, up to 3 months imprisonment and or up to 4,500 New Zealand dollars fine. Loss of license for 6 months or more. All persons over 0.08% BAC/400 I1/4 gram per litre breath, 2 years imprisonment. 6,000 New Zealand dollars fine. Loss of license for 1 year or more. On November 4, 2013, the government announced that the limit would be reduced to 0.05% BAC, with instant fines and demerit points being imposed on those between 0.05 and 0.08%. No date for when the new regime would apply were announced, as legislation would need to pass in New Zealand's parliament. Note that penalties apply to the lowest reading taken across both breath and blood tests. For example, if a driver 20 years or over has a breath test result of 426 I1/4 gram per litre but a subsequent blood test returns 0.077% BAC, then the driver is not charged with any drink driving offence despite the breath reading being over the breath alcohol limit. The penalty for injuring or killing someone when under the influences is the same as dangerous driving. Other countries in Oceania: French Polynesia, 0.05%, Micronesia, 0.05%, Parlay, 0.01%. See also, blood alcohol content, breathalyzer, DWI court, expungement, sobriety checkpoints, references. External links, roadsafety.qld.gov.au, fireandroadsafety.gov.uk, LTSAGOVTNZ, Break the Law, Pay the Price, Ontario Ministry of Transportation website educating drivers on the consequences of being caught driving impaired in the province, Campaign Against Drinking and Driving, Impaired Driving, Medline Plus, Drink Driving Limits in Europe Safe Travel UK, Blood Alcohol Concentration Limits Worldwide ICAP.org.